For decades now, Bob Moles has been instrumental in shining a light on the issue of wrongful convictions in Australia. He has worked on cases including that of Mr. Bromley and been instrumental in initiating much needed law reform in South Australia in the form of a second appeal. In this presentation, Bob reflects on the continuing questions that surround the work of Dr. Colin Manock in South Australia.
Thank you very much indeed. It's a great pleasure to be with you today. It's obviously an important topic that we need to deal with. I just wanted to mention at the outset that if you were to Google Dr. Manock homepage, that's M-A-N-O-C-K, Dr. Manock homepage, Google will happily provide you with a link to my website. And at the top of the Dr. Manock homepage, you'll find links to a range of other materials, which I've put up there especially for you today, to help you follow and confirm some of the issues that I'm mentioning during the course of my talk. During my talk, I will refer to the name and circumstances of the death of a deceased Aboriginal boy and the circumstances of the dealing with an Aboriginal unnamed deceased man. I do so in the interests of justice and with due regard to the sensitivities of the families and communities involved. In the last 25 years, there have been roughly 4,000 wrongful convictions identified in comparable countries, cases which have otherwise exhausted all avenues of appeal. The US has found some 3,200, Canada has over 80, the UK around 570 as a result of the work of the Criminal Cases Review Commission, and Australia and New Zealand, not very many. We can say with confidence that amongst all those cases, there has not been one of them that compares with the situation we have identified in South Australia. Before I explain what I mean by that, I should first emphasise one of the most significant issues found to be the cause of wrongful convictions. As mentioned by Malcolm McCusker, that's in the failures in the duty of disclosure. Duty is important in this context as referring to something which is mandatory, not discretionary. It requires, in the context of the prosecution case, that if the Crown knows of any matter which goes to the credibility or competence of a prosecution witness, or may open up a new line of inquiry which might benefit the defence, it must be disclosed. It doesn't matter whether the prosecutor had personal knowledge of the information or not. It includes anything which is relevant and in the possession of or available to the Crown, which includes the police, forensic services, government departments. The prosecutor must make inquiries to see if disclosable material exists. The obligation is continuing post-trial and even post-appeal. The recent cases emphasise, and I quote, "The duty of disclosure is owed to the court and not to the defendant. It is not a duty enforceable at law at the instance of the accused." I now need to inform you of some of the issues which have occurred in South Australia, issues which have not been disclosed as part of any criminal proceedings, in securing approximately 400 criminal convictions, and which we say ought clearly to have been disclosed. Dr. Colin Manock had been the chief forensic pathologist in South Australia for 27 years, from 1968 to 1995. In that position, he gave evidence in many of the most important cases over nearly 3 decades. So what sort of evidence do we say should have been disclosed? We know that prior to his appointment in 1968, he had no formal training in forensic pathology. We know that from 1972, he presented as a fellow of the College of Pathology of Australasia. This is a prestigious qualification, which normally requires 5 years of study and 2 rounds of demanding examinations. It turns out that Manock hadn't actually done any of that. He was just given the certificate in 1971, and I quote, "because of the seniority of the position that he held." This was just before he was about to give evidence at the high-profile murder trial of Fritz van Beelen. The Forensic Science Centre had arranged with the College of Pathology to hand Manock the certificate and waive all of the extensive study and examination requirements. Clearly, the Forensic Centre, Dr. Manock, and the prosecutors had a duty to disclose this background in any proceedings in which he made reference to his fellowship in pathology. In the mid-1970s, Dr. Manock took civil action against the Forensic Science Centre and the state of South Australia about the terms of his employment. During the course of those proceedings, Dr. Bonnen, the head of the Forensic Science Centre, gave sworn evidence in which he stated that Dr. Manock was, I quote, not qualified to certify cause of death. He explained that Manock had no training in histopathology, the examination of tissue slides using the microscope, and it is clear that without the histo, any autopsy is essentially incomplete. Bonnen also stated that Dr. Manock had no expert qualifications, and this was a clear acknowledgement that the fellowship referred to was not an expert qualification. That meant that Manock did not comply with conditions for appearing as an expert witness in court. That sworn evidence from the head of the Forensic Science Centre, which was never disclosed in any criminal trials in which Manock appeared, was quite sufficient to ensure that any convictions in which Manock's evidence had made a material contribution to the outcome must be in question. In addition, it was established that in many cases, Dr. Manock gave crucial evidence which had no scientific basis to it. For example, Fritz van Wielen was convicted of murder in the 1970s. The timing of death was crucial and based upon the visual inspection of stomach contents of the young girl who had been killed. Manock was insistent that he could give a very precise time of death. Shortly after the conviction, Professor Horowitz and Dr. Pound published an article in a scientific journal to say that the time of death he had given had no scientific basis to it, a view which was subsequently supported by the High Court of Australia some 40 years later. In 1979, David Zack was convicted of the murder of a prominent criminal lawyer in Adelaide, the notorious body in the freezer case. At the trial, the prosecutor told the jury that Dr. Manock's precise time of death calculation put the accused at the scene when the death occurred. As he told the jury, if Dr. Manock's time of death was correct, then it put the accused in great trouble, as indeed it did. The simple fact was that Dr. Manock's time of death had no scientific basis to it. Just 5 weeks before the Zack trial, Dr. Manock's deputy wrote to the coroner to say that any calculation of a time of death using any of the existing formula would be reckless. Yet the prosecutor told the jury they could rely upon Manock's scientific opinion without revealing to them what his deputy had said. And some years after Zack's conviction, a world-leading expert on timing death from post-mortem temperatures said in his written report that Manock's calculation in this case had used figures, quote, plucked from the air. In 1978, in a remote Aboriginal town, Dr. Manock chopped up the body of an Aboriginal man in the high street in front of the shocked local people. He removed the internal organs and threw them into a metal bucket which was standing at his side. Then, scooping up the bodily fluids from within the chest cavity, he offered the ladle to the bystanders, asking if anyone fancied a slurp. The detective from Adelaide, instead of arresting him, was reported to have said, "Oh, typical Colin." Some years later, Dr. Manock's deputy was to inform the medical board that a pathologist cannot do anything to a deceased person without the explicit consent of the coroner. Who is to do it, where and when they can do it, and clearly not in the street and not in front of those known to the deceased. It was around this time that the Crown used Dr. Manock's evidence to secure the conviction of Mrs. Emily Perry for the attempted poisoning murder of her husband, Ken. The High Court, in overturning the conviction, stated that Manock's evidence was, quote, not fit to be taken into consideration. It said prosecutors should use people who are substantially and not just nominally experts in their field. And shortly before Mr. Bromley's trial commenced in 1984, Dr. Manock had completed the last of 3 job applications. The first was in March 1968, the application for the job of Chief Forensic Pathologist. He said that whilst he was in Leeds, he had completed 1,200 coroner's postmortems, of which, and I quote, 30 were murder cases for which I was personally responsible. Sounds a bit like a confession to me, I have to admit. The second was in May 1977, an application for the post of Director of Forensic Pathology. This time, he stated he had completed 1,400 coroner's autopsies with 35 homicide cases. And I quote, in which I was wholly responsible for the medical investigation and the presentation of evidence. This is an increase of 200 additional autopsies and 5 additional murder cases. His claim that he was wholly responsible for the evidence in 35 homicide cases is, in the light of what we now know, a deeply disturbing claim which should no doubt be reported to the UK Criminal Cases Review Commission. The third application was on the 5th of August 1983, an application for the post of Director of the Forensic Science Centre. He stated then that he had completed 1,845 coroner's autopsies whilst he was in Leeds, and this is a 50% increase in the numbers of autopsies declared in his original job application. Somebody's not telling the truth somewhere along the line. It should also be noted that all 3 applications were to the same Forensic Science Centre. Even the most basic due diligence would have brought to light these anomalies. In each of these last 2 applications, he had also put the chief prosecutor in South Australia as a referee, one of whom was just about to prosecute Mr. Bromley at his trial. In 1985, in the case of Gerald Warren, a 15-year-old Aboriginal boy, Bannock initially said the death was a result of an accident. He was later told that, in fact, it had been a murder. Unfortunately, his interpretations of the medical evidence said more about his ingenuity than his scientific knowledge. He initially said the marks on the injuries were caused by the corduroy of his trousers, as his face came into contact with them as he fell from a moving vehicle. He later agreed they had in fact resulted from blows from a metal pipe with a thread on the end of it. Initially, he'd said that Gerald had fallen from a moving vehicle whilst intoxicated. He later agreed the injuries were in fact caused by the utility vehicle being driven backwards and forwards over his body. He excused his apparent inconsistency in his findings by explaining that the physical forces in both scenarios would have been very similar and the injuries in both cases would be indistinguishable. Of course, nobody believes that to be true. In the Terry Akrotidis case in 1990, Dr. Mannock had not undertaken the initial autopsy, but reported to the coroner on the case. Mannock said the young man had committed suicide by jumping from a high tower. He said the body, falling partially inverted, hit the roof of the adjacent building at 100 kilometres per hour. He said the impact of the body knocked a hole 1 foot square through the thick, heavily reinforced concrete roof without causing any serious external injuries to the body. Mannock said that this was because his clothing, a shirt and a pair of jeans, and I quote, had been interposed between his body and the surface that it struck. It does not satisfactorily explain how he could have sustained the serious internal injuries which killed him, yet have no damage to his skull, which was clearly not protected by the clothing. Mannock had changed the time of death from that given by the first pathologist, who said it had occurred 12 hours before his body was found. It was subsequently revealed that he would have been at a country police station at that time. Dr. Mannock said the actual time of death was in fact 12 hours before the body was undressed at the autopsy. Made a big difference. The only problem with that was that it now meant that Akrotidis, on Mannock's information, had died around 2 hours after his dead body had been found by the police, when it was already stiffening with rigor mortis. Mannock's evidence about the suicide clearly avoided an inquiry into what might otherwise have been a death in police custody. In 1992, Dr. Mannock was called to the home of Peter Marshall. He was found lying on the floor of his unit with blood pooling around his head. Dr. Mannock told those in attendance that Marshall had most likely bumped his head on the bedside table as he fell out of bed. He also suggested it might have been an aneurysm because of the amount of blood around his face. Of course, an aneurysm may lead to internal bleeding as a result of a burst blood vessel, but it cannot explain bleeding external to the body. Mannock's explanation resulted in the autopsy being delayed whilst the scene had been cleaned, and he then announced a day or two later, after scans conducted during the autopsy procedure, that in fact Mr. Marshall had been shot in the head and he had a bullet lodged in his brain. Mannock, who had been a self-proclaimed gunshot injury expert, according to his CV, had failed to notice the speckling, which indicated the weapon had been fired in close proximity to his face. He also failed to notice the source of the bleeding was a hole in the skull. Dr. Manock had also investigated the deaths of 3 young babies, each under 1 year of age, and all 3 unrelated to each other. He determined that they had all died of bronchial pneumonia, a chest infection. In a subsequent inquiry conducted by the coroner, the evidence clearly indicated that they had each suffered severe non-accidental injuries. One had 15 broken ribs. There was also a fractured skull and a very serious fracture of the spine, in one case along with other broken bones and burns. The coroner found that Dr. Manock had said he'd seen things that couldn't have been seen, such as signs of a chest infection, because they didn't exist. He found that Manock's autopsy reports achieved the opposite of their intended purpose. They closed off inquiries, police inquiries, instead of opening them up. He found that Manock had given answers on oath that were spurious, which means not genuine, not true. The coroner then decided, remarkably, to keep his report a secret. He said he was sensitive to the fact that Mr. Keogh's trial was about to start. He knew that Manock was to be a principal Crown witness. And so, as he said, to avoid a mistrial, he decided of his own volition to delay publishing the findings until after the trial had concluded. Clearly, a mistrial would have been much preferable to the 20 years of wrongful imprisonment for Mr. Keogh. This is the most serious non-disclosure by a judicial officer, and one which was not the subject of any disclosures by the Crown in relation to the subsequent judicial procedures of Mr. Keogh and Mr. Bromley to this day. We provided submissions to the medical board and asked them to investigate Dr. Manock's unprofessional conduct in the case of Mr. Keogh. In Dr. Manock's evidence to the inquiry, he contradicted the evidence he had given at Mr. Keogh's trial on a number of issues, especially concerning the means by which the so-called murder had occurred. We subsequently found that in their internal communications, the forensic pathologists on the board were scathing in their references to Dr. Manock's incompetent and substandard work, and the fact that he had no formal qualification in his specialty. As we started our work to get Mr. Keogh's conviction reviewed, we were astonished to find that once a person had been convicted and had had an unsuccessful appeal, they were not entitled to any further legal review of their case, despite there being overwhelming evidence to show that they had been wrongly convicted. We brought an action to the Court of Appeal, and we were told that they could not even look at the fact that Dr. Manock's evidence had been false and misleading. They said incorrectly, in my view, that the legislation governing criminal appeals was quite clear and only allowed for one appeal. A further proceeding in the High Court met a similar fate. Only one appeal allowed. But both courts had referred to the petition procedure. An application could be made via the Governor to the Attorney General to exercise a statutory power to refer the case back to the Court of Appeal. However, the law on this was also clear, sadly. The petition procedure was declared in von Einem to be, quote, beyond the reach of legal rights. The Attorney General, it was stated, could refuse a petition for any reason or for no reason at all. We subsequently quoted in our book, criticising this, the Chief Justice of the High Court, who had stated that no legal official could ever have an unfettered discretion. Whilst we continued to keep the Attorney General supplied with a petition at all times for Mr. Keogh, we realised a circuit breaker was required. After all, isn't it the definition of madness to keep doing the same thing over and over again and expecting a different result? So we decided to send a Hail Mary application to the Australian Human Rights Commission to ask them to determine that the criminal appeal procedures throughout Australia were in breach of the International Covenant on Civil and Political Rights. They had been enforced and unamended for over 100 years at this time. Australia, as a signatory to the treaty, undertook to guarantee to all citizens the right to a fair trial and the right to an effective appeal. Clearly, Mr. Keogh had not received either of those two things. He had been convicted on the basis of Manock's evidence, which was clearly false and misleading. He was not informed of those deficiencies before his first appeal was unsuccessful. And when he realised the true position, he was told he had no further access to the court as of right and had to depend upon the goodwill of an Attorney General to do him a favour. The exercise of an administrative discretion was able to exclude him from all access to the courts. In the previous few months, as fortune would have it, we had also submitted a bill to the Parliament of South Australia to establish a Criminal Cases Review Commission on a similar basis to the one established in the UK. That bill had been referred to a parliamentary committee, which had invited public submissions on the bill. We provided them with an extensive submission detailing all of Dr. Manock's serious failings, and that submission was subsequently published by the Parliament, which provided parliamentary privilege to it. At that time, the Human Rights Commission publicly stated in their report that they had agreed with our submission, and they sent that report to that effect to the Parliament of South Australia. It stated that the law governing criminal appeals in all states and territories in Australia was indeed in breach of the fair trial and effective appeal procedures guaranteed under the treaty, and shortly after the Parliament issued its report, it made three important recommendations. The first was to establish a forensic review panel, like a CCRC, but restricted to forensic issues. The second was to establish an inquiry into the use of expert evidence in criminal trials. And the third was to establish the right to a further appeal in criminal cases. The Attorney General acted quickly to implement the recommendation to establish the new right of appeal, but unfortunately he did so without thinking it through carefully enough. It was recognised that legislation was being passed around Australia to derogate from the double jeopardy principle. This would enable a further prosecution to proceed after an acquittal if some fresh and compelling evidence of guilt arose. It was recognised that this change to the law would change a long-held and fundamental principle of the justice system: no double jeopardy. So extreme caution had to be exercised, an application to the appeal court to set aside the verdict of acquittal, the requirement for evidence to be fresh and compelling, and in the interests of justice for the matter to proceed. All well and good in that context. But in the context of wrongful convictions, it was quite different. There should be no great obstacle to investigating a possible wrongful conviction, or indeed acting to correct it. That should be done with alacrity rather than great hesitation and caution. So when the Attorney General said that there should be a higher obstacle to a second appeal, that was simply wrong. The human rights provisions state that there does not need to be more than one level of appeal, but it does state that at each level, all persons should be treated equally. On a first, second, or further appeal, the condition for access to the appeal court should be exactly the same for all applicants. Is it reasonably arguable that has been a serious miscarriage of justice? In addition, the Attorney General, in introducing the legislation, stated that all persons could now have further access to the appeal court, and that was incorrect. Fresh evidence appeals are only a small subcategory of possible wrongful conviction cases. Cases involving unreasonable jury verdicts or errors of law may be just as deserving of review as fresh evidence cases. In our submission to the Attorney General in Queensland, we pointed out that if they were to proceed on a similar basis to the other states, which now include Tasmania, Victoria, Western Australia, in addition to South Australia, they should issue a notice of failure to comply with the human rights provisions of Queensland, in addition to the International Covenant. As soon as the legislation came into effect in South Australia, Mr. Keogh applied for leave to appeal. He was then provided with a forensic report, which the Solicitor General had commissioned in 2004, some 9 years earlier. It stated that the forensic evidence did not support the view that there had been a homicidal assault. It suggested there had in fact been a slip and fall accident in the bathroom. And most surprisingly, the Solicitor General had failed to disclose that report when he received it, or to recommend that the Attorney General make such disclosure. He did recommend that Mr. Keogh's case not be referred to the appeal court. It subsequently took Channel 7 several years of litigation and the appointment of 3 interstate judges to order the release of the Solicitor General's report. And I should say the producer of the Channel 7 programmes, Graham Archer, is here today, and I'm deeply grateful for the more than 10 years of work that he did in producing a brilliant series of programmes on miscarriage of justice issues, and particularly on Mr. Bromley's case. Thank you, Graham. It subsequently took Channel 7 several years of litigation and the eventual appointment of 3 interstate judges to order the release of the Solicitor General's report, because the former Solicitor General had by then been appointed to be the Chief Justice in South Australia. On the hearing of the appeal, the court determined consistently with that report, with the assistance of other experts, that Dr. Manock's evidence at Mr. Keogh's trial had been false and misleading on important issues, and other possible causes of death had not been properly explored. As we turn to Mr. Bromley's appeal, we find that in many respects it was very similar to that of Mr. Keogh. Both cases involved a suspected drowning. The chief witness for the Crown in respect of cause of death, time of death, and the identification of injuries in both cases was Dr. Manock. At the time of Mr. Bromley's appeal, it was clear that Dr. Manock's fellowship was not evidence of expertise. The Forensic Science Centre and the State of South Australia had declared to the Supreme Court that he was not qualified to do autopsies or to give evidence about them in criminal proceedings. The High Court had determined his evidence was not fit to be taken into consideration in the Perry case, and that it had been without scientific support in the Van Beelen case. He had failed to diagnose properly the cause of death in the Zack, Warren, Akratides and Marshall cases, and the coroner had declared his evidence to be untruthful on oath, and his autopsy reports achieved the opposite of their intended purpose, and that he had claimed to have seen things which could not have been seen, just as the court had already determined he'd done in Mr. Keogh's case, just before Mr. Bromley's appeal. However, it should be noted that the comprehensive failings of Dr. Manock in terms of his qualifications and other cases had not been mentioned or admitted in any previous court proceedings. Keogh's conviction was overturned because Manock's evidence was just comprehensively wrong in that case. Mr. Bromley was determined to change all that. He spoke and wrote to his learned senior counsel at the time, a Sydney barrister, emphasising the need to put Manock's lack of qualifications at the forefront of the appeal, because that would mean that the whole of his evidence would have been inadmissible. No need to question the cause or timing of injuries then. The barrister determined that he would do that, but would in addition provide expert evidence to support the claim that Dr. Manock did not know how to properly diagnose a drowning case, just as he had done on the Keogh appeal. In fact, he had the same experts for the prosecution and the defence who had both given similar evidence in the Keogh case. They said Dr. Manock's evidence about the timing and cause of bruising and of injuries in relation to a body which had been in the river for 5 days, in Mr. Bromley's case, had no scientific support. His autopsy's findings, they said, were so incomplete he could not exclude a death by natural causes. Unfortunately, just before the appeal concluded, his senior counsel informed the court that the evidence about Manock's history of failings and lack of qualifications would be withdrawn. The other evidence about his findings in the case would remain. Regrettably and incorrectly, in my view, the appeal court decided that the remaining evidence about Manock's autopsy procedures was not sufficiently compelling to pass the test for leave to appeal. Evidence from the pathology experts in Mr. Keogh's case, sufficient to require the conviction to be set aside, now appeared insufficient for the grant of leave to appeal for Mr. Bromley. Unfortunately, the adequacy of the reason by the appeal court would not be subjected to review by the High Court, as they, as you've already heard, explicitly and without reasons being given, excluded the forensic pathology evidence from their consideration, which regrettably led to the refusal by a majority of leave to appeal. Possibilities for the future clearly include the provision in the new right of appeal legislation for a second or further appeal. Evidence about Manock's lack of specialised knowledge based upon study or training could now be used as fresh evidence to trigger a further appeal. Another possibility is that which was raised in the High Court in one of Mr. Keogh's applications to the High Court, was that involving an application based upon fraud. Mr. Game KC had drafted an application which had not been activated but was sitting on the court file. The Chief Justice, having noticed it, asked if the application to the High Court was refused, whether that previous application would be filed to commence those further proceedings. Mr. Game said he expected that it would. Whilst that did not eventuate, the possibility is still available. Fraud involves an application to the Supreme Court to commence fresh proceedings. It is not an appeal, and so does not invoke the troublesome fresh and compelling evidence arguments. In a recent case in the High Court, it was stated by the High Court that it allows a single judge, in the presence of fraud, to set aside a decision of the appeal court or even of the High Court itself. We even included a chapter on the fraud issue in each of our 2 recent books, which I meant to pull out of my little bag over there, and I will do shortly, in each of our 2 recent books discussing fraud as an option in such cases. And we did so because we thought it should be on the table as an issue to be discussed. It is this aspect which distinguishes the Manic fiasco from all the other 4,000 wrongful conviction cases we spoke of earlier. In no previous jurisdiction or cases has the state itself given sworn evidence that a state employee was not qualified to do the work or give evidence about it in court, and then instructed that person to conduct 10,000 autopsies and to secure over 400 criminal convictions. Surely the time has come for a proper judicial inquiry or royal commission into the Manic cases, and a more effective means by which such cases can be reviewed and returned to the courts without any further delay. Thank you very much.